Hello, everybody out there. Hope you're doing well wherever you are, whenever you're watching this. Happy Friday or Saturday or whenever it is. To those out there I see on the comment board, since I've kind of started doing this, it's kind of fun. I see John. Hi, John. Born Free Films, the one, Dustin, Jack Hamilton, Tebow, Alex, Rondell, you, Northern, nice guy. Hello, everybody, and everybody else out there. Thank you for joining. I think we have an exciting day. I wasn't excited, and then I got excited about 5 minutes ago. Um, so, what I wanted to do is to talk to you about today. I'm going to talk about GTII, surprisingly, um, and we're going to talk about the filing that was done last night that I had a chance to review today, in part. That I think kind of for me, not legal advice, not financial advice. Nothing is done. Anything can happen. We're not near the end. There's plenty of stuff to go on, but I have to honestly say, and it didn't occur to me till like 5 minutes ago, that it feels like light at the end of the tunnel, honestly. And that's the first time that I've actually had that exciting feeling that I can actually see the end. And again, anything can happen, and whatever. But interesting for me, just kind of personally, it was the first time, kind of after I kind of had a chance to process this, that I felt, wow, we're actually moving ahead and making progress. So what a teaser that is, right? What a great teaser. Before we get into that, I had a couple things to say. Besides, it's not legal advice. Please comment. I enjoy the comments, and I look at everybody's comment. I do. I look at all the comments, or at least try to. And feel free to comment. And great. And I appreciate all the comments. Appreciate everybody who looks at this. Share it, subscribe, all that nonsense that people all say. Did you hear, by the way, about the cannibal CPA? He charged an arm and a leg. What do CPAs and accountants like most about the weekends? They can wear their casual clothes to work. And what psychological disorder do accountants suffer from? Depreciation. And finally, and it's the bonus one today, you get a bonus one. This one was made up today by me. It's more of a question. Who reduces FICO's credit score? You tell me that one. It's like who's going to audit the IRS? Anyway, so we've been talking, now we're going to flip. GTII. So we've been talking about GTII and all kinds of stuff, and I had been kind of alluding to two motions that needed to be filed. One about claims, and that was filed and is going to be heard coming up on the 27th of May, and I will be in attendance when that is heard, either 27th or 28th. I think it's going to be the 27th. At least there's a bunch of things said on the 27th and some on the 28th. I'm presuming everything will be heard on the 27th. But one of those is a claim motion that basically says if you have some claim, like, you had a claim against GTII, you entered a contract and they didn't deliver widgets to you, whatever. It set up a process whereby there would be an end date. And, if there was a dispute, ultimately the court would decide if anybody had a legitimate claim and if there was money to pay those claims. So that's been filed. What I was waiting for and what I kept on alluding to was some kind of share motion. And the issue was, and just to kind of tell you what the share motion was, what I kind of understood it to be, and now since I have it in front of me, again, another fairly lengthy document prepared by the Receivers Council. What the concern is we have a bunch of shares that are owned by, according to the receivers reports, there's a lot of shares that shouldn't be owned by people, that shouldn't exist, that shouldn't have been owned by management, that shouldn't have been distributed by management. The receiver goes in much harsher language than I'm using, but that's kind of the way it is. And per the order that established the receivership, it permits the receiver to go back and claw back shares that were not properly obtained. And the receiver is used, I presume, and this will be clearer as time goes on. Receiver has his own accountant and a forensic accountant, and I'm sure that person went back and went through all the records that they could of GTII, and through those records, they were able to generate a final score of shares that they deemed that were like suspect shares. In other words, they claim, the receiver is claiming in this document, this motion, that all the shares were basically requested through David Reichman, and they went to various entities and people. And I'll go through all the people really quickly, but there's 87 of them, but all through kind of originating through David Reichman. And the allegation by the receiver is, one, sometimes it might involve officers and directors, and they were kind of involved in the entirety of the scam and fraud, and they shouldn't be getting them. Or two, they were given for services or purported services, but there was no evidence of any kind of service that was provided. They were basically wasting corporate assets. Basically, our money is the point. And the receiver has gone through and has totaled up that amount, and it's about 178 million shares. And the receiver went through and I guess looked at the total ownership. The total number of stock owners of GTII is approximately, and these are approximate numbers, but about 15,500 shareholders. Average shareholder has apparently about 5,500 shares. These shares, I'm going to call them, for the purposes of this discussion, the bad shares. That's not what the receiver says. The receiver has a different way of identifying. I think he calls them illicitly obtained shares, but we're going to call them bad shares. That is more than all the shares, or a substantial amount compared to the actually legitimate shares. So the process that the receiver has set up is on the 4th, or at least that's what appears to be, on June 4th, there'll be a hearing to basically set a procedure, and also to prohibit any future action with regard to these shares. So in essence, what the order is to seek to lock up all these shares, so there's nothing that can be done with the shares. And one of the things that's reflected in there is apparently the receiver learned that recently one of these parties, or more than one, who the receiver claims to have illicit shares, tried to move them to somebody else. So this particular filing, and it's called an objection and a motion. So the objection is to all these 178 million shares, basically say they were illicitly obtained. They were done basically through David Reichman, no consideration, or through directors who participated in the misconduct. And then a hearing would be on June 4th, according to the way it's set up right now. And at that time, what the receiver is asking is that there be a freeze, so there can be no transfer of shares like apparently they stumbled upon. And that if someone wants to contest the status of that, of what the receiver has called them, because the receiver is basically, that's my usage, my opinions, just my terminology. But the receiver is basically saying, hey, these shares are bogus shares, 178 million. So we would need to set up a procedure whereby all these people, if they claim they're not bogus shares, have an opportunity to show us evidence why they're not bogus shares, whether they be, showing invoice for services or something else. And the way it's going to work is, if in fact the order is issued on June 4th, and it may not be, but let's just use that date for the process. Apparently, the way it's set up now, then anybody who objected to that status, that their shares were bogus, would have 60 days to file a motion with the court, and then that would probably be heard within 30 days thereafter. Now, I'm going to talk about the motion and what the problem would be if they file a motion. But I want to throw out another thing. Is one of the other things that's referenced in here is that the receivers or receivers council has been in contact with a lot of these shareholders who own these, my language, bogus shares, or as the receiver said, illicit GTII common stock held by identified shareholders. However you want to define it, it's shares that are in question. But they say they've spoken to many of these shareholders, and many of those have agreed to return their shares. It's not yet reflected, and as part of this filing that was today, actually the filing is May 22nd at 5:32 p.m. It's almost 24 hours ago, but after hours on that. But attached to this particular objection and motion is a release. And part of this request is the receivers asking for permission that if people want to turn back their shares, that they'll be released from liability. And, that might differ based upon who it is. It might be something to have to be thought about. But in general, I think it's a good idea. So, if somebody has 100,000 shares, wants to return it, they weren't involved, but they're shouldn't have the shares, and they want to have a mechanism where it won't get sued, then that's a perfectly legitimate way, and I would support that. The breadth of the release might be an issue, but I haven't had a chance to thoroughly review the mutual general release, which is going to be Exhibit D to that filing, the receiver's omnibus objection, the start of the document. But sounds like a bunch of shares will be returned, so that's good, and so I expect that 178 million share amount to dramatically be reduced. And remember, the return of those shares is a prerequisite or seemingly a prerequisite of getting any deal done. So that is fantastic. In my opinion, that's fantastic news. Now, what's interesting also beyond that is if somebody's going to object, well, one, again, I don't know about all these transactions, and maybe their receiver's inaccurate, and maybe the information is not accurate. So keep that in mind when I reference anything. But I don't know if these people get these shares, if they pay tax on these shares. Have they paid tax on these shares? Wouldn't that be like a real incentive to give the shares back if they hadn't paid tax? Because that might be, that could be problematic in of itself. And then, if certain people held certain positions that were larger than, let's say, 5%, that might also create certain reporting requirements that might give you certain other issues. And those are huge issues. So that's two parts. And three parts, if the shares were obtained in an unlawful, fraudulent, or improper way, and somebody has to submit a declaration under penalty of perjury countering that. This is a question to all you out there. I mean, if you got to lie under penalty of perjury to try to keep your shares, isn't that a crime? Just a question. And in this case, it would be to a judge. So, you can perjure yourself in a lot of ways, and a lot of time people get in trouble for like bank documents and that kind of stuff. But here it would be with regard to a court document. Didn't seem like that would be like a real good method of approaching that issue. So, just my thinking, and to anybody out there who's going to be listed on this 87-person list, and I'm going to, and what we're going to do is, I think, is a exercise just so everybody can have the benefit of showing who the good guys are. We'll start off with the 87 today, and about every 2 weeks, we'll kind of go over the list. And to the extent we know if that list has changed, we will then say who's dropped off the list. We'll give those people credit for having resolved their issues, and we'll move on from there, and we'll see who's left over. But ultimately, again, I'd be shocked if somebody wants to put their testimony under penalty of perjury to claim that some transaction related to actions that appear to be suspect were kosher and 100% kosher. I don't know. It would make me uncomfortable. I mean, maybe all of them are, but at least the receiver seems to question a lot of them. So anyway, this process where somebody might dispute the share that, their entitlement to the shares might be very interesting. Of course, I'll get to participate in that and file briefs too, to the extent I think it would be necessary. And I'll get to attend the hearings and argue them as me and alone as an attorney, but obviously with my mind and interest solely for you guys. Solely for you guys and me. How's that? So let's talk about who's referenced. So let's see. I talked about what this is, that they'll be hearing on June 4th. Then there'll be like a 60-day period to assert a claim, but you'll basically have to put on evidence and under penalty of perjury, then probably a hearing within 30 days, and then the judge will decide. But again, you're going to do it under penalty of perjury. So I'd be really careful if I were you, really. It's not like this is not being looked at, right? It's not like the SEC doesn't look at Alpine all the time and might stumble upon this. It's not like the IRS may not stumble upon. I mean, I think this issue is foul, and per the receiver's reports, it does seem to be foul. So let's just go through the list. Now we're going to go through a list. This is the fun part. We'll let everybody get the props that they deserve for being included in the 178 million plus of according to the receiver, illicit shares. Number one, AI Commerce LLC. That was some transaction. It was supposed to be that didn't happen, involving 20 million shares. Nothing, no transaction completed, no consideration. That's what you're going to hear. No consideration. So in other words, if the shares were given to somebody, they didn't get. There's no value returned. That's ultimately it. American University. And some of these I'm just going to do, even though they're small, just because it's kind of funny. I think it's kind of funny in a pathetic way. 11,000 shares to American University, and the receiver thinks, and I'm looking at page 13 of 35, line 5, that it might have been to like ease the way for Justine Reichman's children to be accepted into the university. I don't really think that's a great purpose, a GTII purpose. By the way, this goes over and beyond. This is kind of like sub-detail of what we spoke about in the receiver's report. Then we have Ann Muriel, and if I butcher anybody's name, I apologize. I'm not the greatest with names, so I'm doing my best. Ann Muriel and Marcos Muriel Zoleta, joint tenants, they hold 200,000 shares. Apparently, Ann Muriel is the daughter of Kathy Griffin. Kathy Griffin was one of the 2 employees of GTII, along with David, and was on the board of directors, and basically was the number 2. And apparently that was for some PowerPoint presentation. Nothing to back it up, according to the receiver. And Antonella Boglio, 165,000 shares. And again, all these say issued at the direction of David Reichman, all these. So if I don't repeat it, just assume it's in there. And this was determined to be, she's a friend of David Reichman's former girlfriend. So that's nice. That's good. Obviously, no evidence that anything of substance was performed. Arthur Schwartz, about 600,000 shares. He was either David Reichman's friend or uncle. No consideration. He's now deceased, and it just happens to be that Reichman is the beneficiary of that estate. Anthony Matassa. Sorry, Anthony, if I misspelled your name. Matassa. 550,000 shares, and he was the fabulous mechanic for David Reichman. Wow, David Eichmann. That's interesting. David Reichman's Bentley. So he got 550,000 shares. No evidence that was done for the benefit of GTII. And again, I don't know, like, of these people that I've mentioned so far, I don't know which of them has agreed to return the shares, because some of these people, and we'll know as time goes on, because we will get information from the receiver about either settlements. There might be filings. There might be 8Ks that are filed involving the releases. But there will be notice eventually of who went on. It'll be interesting to see who left, and then we could compare it to what they were, what they got. The mechanic, I think, that's a tough one, even if he's a great mechanic. Bill Glasser, 550,000 shares for unsubstantiated advisory services in connection with the David Bassell, Bassal Trust. of which David Reichman, was the trustee. Bioenergy System Management LLC got like about 100, and I'm rounding these numbers each time I'm saying it, 163,000 shares. And they determined that this was just a incomplete, failed transaction, and that Bioenergy System Management LLC, if you recall, when we talked about the receiver's last report, there were a bunch of subsidiaries that were created and never used. Here's one of them. And no consideration, nothing done. Bull Consulting Group, 165,000 shares. Some issued contingent upon services, no evidence of any services, again, through David Reichman, at the direction of David Reichman, as all of them say. Barbara T. Anderson Irrevocable Trust, 340,000 shares. And she apparently was a romantic partner of David Reichman. No consideration or no evidence of consideration according to the receiver, etc. But I guess it paid to be a romantic partner of David Reichman. You can draw your own conclusions about that. Bethany Dudick, 125,000 shares. She's the sister, apparently, of Kathy Griffin. We're looking at page 14 of 35, line 14 of this document. And again, it's claimed that they were issued under dubious circumstances without any consideration, material consideration, and no evidence. I mean, there's no like documentation. There's nobody who submitted an invoice. There's no minutes, nothing really. If you looked at it and there hadn't been, purported misconduct, it would still smell fishy. If you put it in the context of all the misconduct that's alleged, it's beyond squishy. Here's an 11,000 shares to a Ben Namadi, a friend of David Reichman. It's only 11,000 shares, but it didn't really make a difference. Seems like, the postman came, here's 50,000 shares for bringing me my mail. That's kind of the way it looked, which is pretty nice for the mailman. I haven't seen the mailman's name listed here yet, but I'm looking very carefully. Brent, and if you know anybody here, let them know. Brent Golub, Golub, 50,000 shares, apparently a friend of David's. Nice. Christopher Cecil, 165,000 shares at the direction of David Reichman. And apparently he was a former insider to the company. I don't know what he did. I don't know when, but that's what the receiver claims. He's an insider. And basically this is waste committed by the management, basically giving away assets that should belong to us. Saya-esque Holdings, 768,000 shares. This apparently, I'm looking page 15 of 35, lines 2 through 9. The reason why I say that is if at some point in time you have this document, you can go back and you could look at these sections and you could spend some time and try to decipher them, because it's pretty confusing. If you're going through it, there's a lot of people and transactions. And if there wasn't anything going on, would there be all these people and transactions? I mean, do you have to have like 87 different stock transactions to people that are either friendly or insiders on a company generating zero revenue without notice, apparently without notice? I mean, does that really make a lot of sense? Of course not. So this apparently was with David Reichman to attorney Roy Lester. I don't know what he did or whatever. And then some entity formed by Warren Moskowitz. And if you recall, Moskowitz was an attorney of GTII. I had interactions, some very minimal interactions. I think he prepared a opinion letter on the dividend, and per the receiver's report, at some point in time, he prepared like 144 opinion letters along with somebody else for the benefit of other shareholders, none of us, by the way, but other shareholders. And there's some dubious transaction in which apparently Lester gets 1 million shares, or he was involved in the sale of 1 million shares sold to some entity that was the entity created by Markowitz. Anyway, smells bad and whatever. 440,000 disputed shares for the Daniel Bassell Trust. And Daniel Bassell is an adopted son of David Reichman's friends. And Reichman is a trustee of the trust. Very nice. Again, it pays. Maybe it doesn't in the end. Because just think about this. If you're one of these named people, that means you've been contacted by the Receivers Council. If you want to contest this, you have to incur a substantial amount of legal fees. If you don't want to contest this, you have to incur legal fees. Either way, it sucks. But what's if you still have the shares, that's one thing. If you don't have the shares, what do? Are you obligated for the monies that you got? Do you have to return them? It seems like a pain in the butt. I certainly would not want to be involved. Well, that was an apt place of stopping. With respect to David Reichman, so what they've done here is they have, and I think his value is zero. His value is probably negative dollars. I think I could put on an expert to say that he not only was worth zero, but was worth negative dollars. But I think in this computation, page 15 of 35, lines 16 through 20, they determined that his value. It seems to me what it's saying. His value is something on the order of $3 million during the course of time, and that even including that, he's the holder of 44 million disputed shares, and he shouldn't receive them. And obviously, the receivers reports are filled with reasons why Mr. Reichman shouldn't retain those shares. He could dispute this, I guess, and he may. If he disputes it, again, it'll be interesting because is he going to testify under penalty of perjury? And will that expose him? Will that expose him? And is he willing to expose himself to the court and under penalty of perjury to go after these shares? Or will he finally admit that, no bueno, and let's move on? Either way, if he disputes it or if he doesn't dispute it, it'd be pretty interesting to see how he goes about how he says it and if he does it, in my mind. And 44,655,000 shares is the most of any of these categories of the 178 million shares. And that's obviously a substantial amount of money even at 10 cents. At 10 cents, that's $4.5 million. So it's a substantial amount of money, and depending where that goes or how it's treated, that's a big deal. And again, interesting to see how it's disputed. I would expect, I'd expect there'd be a lot of thought about what they're going to do and how they're going to present that. Daniel Marcus, 320 million shares, and this is per some medical advisory committee, they call it the MAC, was set up as appears to be some kind of like charitable type organization. And here he is. He's a friend of Reichman, a member of that committee, and he got 320,000 shares. Without consideration, no evidence of anything having been done. Derek Gilbert, who was apparently related to, he's the son of former board member Don Gilbert, was given 550,000 shares, apparently in a dubious manner. In other words, no reason in particular for it to give, and there's been no evidence apparently why they should be given 550,000 shares. With respect to Donald Gilbert, the father, he's the holder of almost 5.3 million shares. He was a former director and oversaw. This is what the receiver is saying, page 16 of 25, lines 3 through 8. He was the former director of GTII and oversaw and participated in the frauds perpetrated by David Reichman. So why wouldn't somebody like Donald Gilbert want to give back his shares? I don't understand why they would want to contest that. In fact, matter of fact, somebody like that who seemingly has a lot of exposure in a lot of ways would, if he was my client, and if I determined that he was in a difficult position, I would try to make a deal with Receivers Council and try to cover myself and provide them whatever assistance and help they could to go after whoever else they needed to. I would protect my kid also, because the kid, if you saw the one before, that's 550,000 shares. I'd kind of like put that in a package, and I'd go to those guys and I'd say, listen, here, what do you need to know? I'm happy to testify. And in return, we get a full and complete release, confidential agreement, etc. And we move on from there. That's kind of what I would do. if I was their counsel. I don't know what they would do, but the fact that it says again, page 16 of 35, line 5, 6. Gilbert is a former director of GTI and oversaw and participated in the frauds perpetrated by David Reichman. Now, again, this is the motion of the receiver based upon all the reports he did. And of course, Gilbert will have Gilbert or his counsel, if they think this is not true, will have an opportunity, as all these people, just so we're clear, all these people can contest what is alleged, and they all have an opportunity. Whether they do or not is another story. And again, like I said, if in fact they're dirty and it would require them to perjure themselves in claiming a justifiable reason for taking the shares, they would be exposing themselves to a big risk, I think. I certainly would advise them, against exposing themselves to that kind of risk, because because that's really, because again, based upon the receiver's report, this has got to be amongst the most dirty companies in terms of how senior management handled things. If the receiver's reports are correct, this is, there is a big problem. And so why would you take that as your backdrop? Would you want to then oppose that and expose yourself more publicly so that you're basically making the case for somebody else? I mean, if you let this case go too far, discovery goes, all the information comes out, it's not going to change the result, and you will have basically proven up the case for any other attorney that wants to use it. So again, doesn't make a lot of sense to me. So if I'm speaking to one of the former shareholders, especially if they're not, former directors, especially if they're not represented, I really think you got to consider contacting the Receivers Council. My opinion, do what you want. Certainly not legal advice, because I don't represent anybody here. But you got 5.2 million shares. Somebody's going to take note of that. Again, I don't know if anybody who got these shares, if anybody's ever paid any taxes. I don't know if taxes were due. I don't know if they've been sales. My guess is they've probably been sales. I don't know if taxes have been paid on the sales. I'd be really concerned about that, probably because when all these people probably sold these shares, they had no concern for these issues, because these issues really arose. I got involved in it. So it's 25 now. I really started getting involved in heaviest time, end of 23, beginning of 24. So I don't think much before that they would have had a big concern about what they did with their shares. That's why I think it's so blatant. I don't think they had a chance to consider it. It's what I don't think they considered the fact we might be discovered. I think they just kind of conducted business as usual, and they got pressed on it, and it is what it is at this point in time. Eric Frank, 100,000 shares. Apparently, is the son of Reichman's cousin, Karen Frank, and involved also affiliated with, I can't tell if this is Karen Frank or the son, one of the Franks, is affiliated with the stock laundering scheme of the Epstein Memorial Committee, EMC, discussed in the receiver's interim report. So that was another thing that was set up apparently through David Reichman per the receiver, and apparently his cousin's son was involved, got some shares. Dr. Stephen Freeland, 155,000 shares. Freeland was Reichman's personal doctor and member of the MAC, that dubious medical committee. I'm reading just in the motion here. Doctor of Reichman, not the doctor of GTII, as far as I know. So there would be no reason you would give shares to somebody who would be providing personal services to somebody and not to the company. But David C. Horton, 11,000 shares, friend of Kathy Griffin, alleged. Dale Marr, 297,000 shares. He was, and maybe is, and I don't know what this means, David Reichman's personal concierge in New York, and stock issued under dubious circumstances, no consideration. And again, is that for GTII or is that personal for Reichman? Seems like, as alleged by the receiver in the motion, personal for Reichman, 297,000 shares. That seems like a little bit of excessive, besides the fact it wasn't apparently done for the interest of GTII. I know I, as a shareholder, never got to use the concierge service to get me like a drink or order movie tickets for me. And I'm kind of upset about that, but so be it. Evelyn Als, I got to spell it, I'm sorry, ALSULTANY, 517,000 shares. That's a significant amount of shares. Apparently, lifelong friends of the Reichman family, grew up with Justine Reichman, and as the sister of Fabian, same last name. We all know Fabian, right? Just joking here. And those shares apparently were issued without consideration under dubious circumstances. Fabian has, get this, almost 7 million shares issued at the direction of David Reichman. I'm looking at page 17 of 35, line 7. And lifelong friend of the Reichman family and Justine, and as the brother of Evelyn, issued under dubious circumstances, and no way has it been substantiated at this point in time. The Francis R. Davidson Trust, 385,000 shares. This is a trust controlled by David Reichman. Frank Benintendo, and there's another gentleman named Frank with a similar last name, but it's not this guy. 5.3 million shares. He was, it's claimed, page 17 of 35, he's a former board member and director, He's director of GTI and oversaw and participated in frauds perpetrated by David Reichman, that the shares were issued under dubious circumstances and haven't been able to substantiate it. So just one of the guys, apparently, according to the receiver, assisted David Reichman on the board at facilitating the distribution of all these shares that the receiver is determined to be illicit. Functional Health Strategies, 225,000 shares. This was an entity controlled by Jamie Frank, again, second cousin of David Reichman. Dubious consulting work and no consideration, etc. I think I'm going to change my name to Dubious, not dubious advice, maybe. I do like that term, dubious, because that really fits the Reichman family very well, because I think they are dubious. With respect to Gabrielle Falanga, again, pronunciation, I apologize. I have to spell it for you, unfortunately. Falanga, over 3 million shares, so she's worthwhile. Disputed shares, as it said here, by the way. Issued at the direction of David Reichman, and as it turns out, Mr. Falanga, I'm going to call him Mr. Falanga, is the son of Natalie Gidalia, Ghidalia, a former girlfriend of David Reichman. The shares were issued under dubious circumstances, and the receiver has been unable to substantiate or quantify any material consideration having been provided to GTII. I read the last part of it. It says on almost on every one the same thing. With respect to Gabriel Negu, Neagu, 55,000 shares. This is some kind of travel-related services, like a shuttle driver or something. Greg Frank, 8,500 shares, husband of Karen Frank. Those stock was issued under dubious circumstances. EMC, 21 million shares. EMC apparently was fraudulently issued stock, and I'm reading now from page 18 of 35 of the motion. With respect to EMC, the receiver, through his investigation, has determined the EMC was fraudulently issued stock to launder for the personal benefit of David Reichman and his friends and family, and as David Reichman's golden parachute, and perhaps golden shower too, perhaps. Doesn't say that, by the way. The receiver has been able to substantiate or quantify any material consideration having been provided to GTI, and I myself find this dubious. 21 million shares. Now, any of those shares sold, taxes paid? Who got them? For what reason? Did they try to conceal them? I mean, the receiver is using the term launder. That's that's a loaded term. So that's very problematic. 21 million shares is not insignificant. Again, if it's 10 cents, it's $2 million. Hopefully for all of us, at some point in time, it's more than 10 cents. But that sounds like really problematic. And again, with allegations, I was thinking about this. So there was a deposition already that took place. It was a confidential deposition. If I was in the case at the time, I would have gone. I wouldn't be able to talk about it, the testimony, but I would have gone. And it involved Justine Reichman, I believe, on behalf of .8. And I was wondering at that time whether she was going to take the fifth on behalf of .8. So if you're in a civil case and you're testifying on matter and you might be incriminating yourself in a criminal matter, you can take the fifth in a civil case. It kind of screws up your defense in the civil case, but if other things are more important, then you may want to take the fifth. So I didn't know if she was going to take the fifth. She did not. And then I see this, and I'm thinking to myself, one, and I'm going to ask, because certainly going to ask to take David's deposition once I'm in the case, which will be on the 20, sometime after the 27th. But if you have to prove this stuff up, you're putting yourself, again, you're going to be signing things under penalty of perjury. It'll be to a court also. Just really, do you really want to battle out the truth under penalty of perjury based upon these facts? I mean, I really think that's terrible judgment. And I've wondered about that. I don't know if former management is infirm, is not competent, does not think correctly, because there's a lot more to lose than to gain from here. I think ultimately they're going to lose all this stuff anyway. And if they battle it out, I just don't see the positive thing other than publicly battle it out and get accused, because I didn't file this motion, but you get accused of all kinds of misconduct, and either you could accept it or you could reject it. If you reject it, then you're doing it under penalty of perjury and risk. And then you're also in a publicly disputing it. Have you paid your taxes? Are there other concerns? If you haven't, aren't you inviting scrutiny there? Doesn't make a lot of sense. And this EMC really sounds like it's problematic also. Hossam El Shea, 11,000 shares. He referenced that MAC, that medical thing, with shares issued under dubious circumstances. Howard Duchesne, 142,000 shares, friend of David Reichman, shares issued under dubious circumstances. The Icahn School of Medicine, and with one designation, 1,000,006 shares, nothing, issued under dubious circumstances, flagrant waste of shareholder assets. Another element of that medical school, 2.7 million shares, same conclusion. Another element of that school, 321,000 shares, same element, issued under dubious reasons and a flagrant waste of shareholder assets. See, for example, page 19 of 35, line 7. Ithaca College, 11,000 shares, no idea, but perhaps to gain favor with Justine Reichman's children. So I guess what they're claiming is, and it's just interesting, that Reichman, or through Reichman or somebody, would use GTII shares, they'd give it to some college to induce them to let their kids come in, apparently. I don't know if the kids were accepted or rejected, or if there was more shares given, or if somebody else gave the shares, but it's interesting. And I've heard of those. There was a big lawsuit. No, but it was more than a lawsuit. There was some Hollywood people who got indicted, I think, at USC for doing that. I think one went to jail. But I don't know if that amounts to anything like this. Janice Keating, about 199,000 shares. She's a sister of Kathy Griffin. Her shares apparently were issued under dubious circumstances. Joel Osteen Ministries, for a failed transaction. I don't know if GTII was going to acquire Joel Osteen Ministries for 88,000 shares, but apparently that didn't happen, and no consideration. John Morrissey, 126,500 shares. Apparently, his stock was issued under, yes, dubious circumstances related apparently to travel-related services for airport shuttle drivers. So you could be a mechanic, an airport shuttle driver, but you can't be a regular shareholder. Those are the only shareholders that get screwed, actually. John Scrudato, I hope I didn't mispronounce his name. I apologize. Scrudato, page 19 of 35, line 21. The holder of 2.5 million disputed shares. He was apparently, this one's a little funny in a bizarre way. He was apparently the former accountant of GTII and responsible for dubious accounting practices. And we've had like that company that got put out of business, and we have a bunch of financials. Apparently, there's a lot of stuff that went on that may be problematic for especially anybody who was in accounting, or touched accounting, because I don't see how you didn't know what was going on. Whoever was involved, and this could be this. I don't know this person, but it could be this. Justine Reichman, 7.3 million shares, the daughter of David Reichman. And this is what it says, page 19 of 35, lines 25 through 26. Daughter of David Reichman was issued stock under false pretense and under dubious circumstances related to dubious consulting work. So she has the honor in the receiver's motion to have dubious twice in 3 lines. And I think she has to get some kind of prize for doing that. Maybe she gets the dubious prize of the day. Karen Frank, we mentioned, I think she was cousin of David Reichman, 210,000 disputed shares. Kathleen, TSERNOU, 55,000 shares. She was involved apparently with that MAC, the medical advisory thing, and also Reichman's personal therapist in New York. Very nice to know. I don't think she was GTII's therapist, and obviously somebody who provides personal services to management shouldn't receive compensation from the company. And again, page 20 of 35, the Receivers Council asserts that these were provided under dubious circumstances. But that must be so annoying when I say that, the dubious part. I apologize for saying it so many times, but I was thinking about this after the fact. That's going to be the title of this entire stock. Dubious circumstances. That covers GTII, Alpine, the regulators, everybody. That's GTI. Dubious circumstances. Kathy Griffin, holder of 13,395,611 disputed shares, page 20 of 35, line 8. Issued at the direction of David Reichman. Receivers determined the former president and director of GTI and worked with or otherwise supported David Reichman on most or all schemes and frauds by Reichman, and the disputed shares were issued under dubious circumstances for which the receiver has been unable to substantiate or quantify any material consideration having been provided to GTII. In essence, they're saying that this 13 million plus shares were provided without GTII getting anything in return, other than like a pain in the ass, or this dispute, or me having to do this on a Friday afternoon on Memorial Day weekend, right? Kent Jacobs, 275,000 shares, again involved in the dubious MAC, that medical advisory committee, and a friend of David Reichman, and that the shares themselves were issued under dubious circumstances. How do you like that? Leslie Schlachter, 502,000 shares, again connected to that dubious MCA group, the medical advisory thing, whatever. And again, also, just coincidentally, a friend of David Reichman. And again, the receiver has been unable, apparently, looking at page 21 of 35, lines 1 and 2, has been unable to substantiate or quantify any material consideration having been provided to GTII. One of my favorites, Afshin Luke Rabari. So I'm looking at page 21 of 35, lines 3 through 9. The receiver claims he holds 8.6 million disputed shares issued at the direction of David Reichman. The receiver has determined that Mr. Rabari, who, if you recall, before I don't remember how he terminated his engagement, but he had come over to be a consultant. He held a position, and then he held the position of CEO. So he was the former CEO of GTII. He was brought in to replace David Reichman, and the receiver says, and essentially be the fall guy for the failure of GTII. That's page 21 of 35, line 6. The fall guy for the failure of GTII. I found that pretty funny. He may not have found that funny. I don't know if they've been in contact, if the receiver's been in contact. I don't know Mr. Rabari's position as to those shares. I don't know what other compensation he got. But anyway, so it just was interesting to see. 100,000 shares to Margaret Williams, again, related to that dubious Mac group and a friend of David Reichman. Matthew Martinez, 66,000 shares, a friend of Kathy Griffin. Michael Valle, VALLE, 1.5 million disputed shares, former director of GTII, and oversaw and participated in the frauds perpetrated by David Reichman and other board members, and the stock was issued under dubious circumstances. Again, that's page 21 of 35. Margaret Griffin, 200,000 shares. She apparently is the daughter of Kathy Griffin, apparently got paid 200,000 shares for a PowerPoint presentation, but apparently, according to the receiver, GTI did not support the issuance of these shares, doesn't have the documentation, etc. Mark Richardson, 303,000 shares, disputed shares. And apparently, Richardson, this is page 22 of 35, lines 2 through 5. I'm going to read it so it's just clear. With respect to Mark Richardson, the holder of 300,901 shares, disputed shares, issued at the direction of David Reichman, the receiver, through his investigation, has determined Mark Richardson has laundered millions of dollars in stock for the direct benefit of David Reichman. The stock was issued under dubious circumstances for which the receiver has been unable to substantiate or quantify any material consideration having been provided to GTII. I think pretty serious allegations there. With respect to the MJ Maklusa Trust, which is like 296,000 shares, that's a trust in which David Reichman is the trustee, and of course, dubious circumstances. Natalie Gidelia, GHIDALIA, 11.5 million shares, disputed shares, issued at the direction of David Reichman, and as the mother, she is the former girlfriend of David Reichman and the mother of Gabriella Falanga, who I think also got shares. So apparently, the former girlfriend of Reichman got 11.5 million shares under dubious circumstances and nothing to substantiate or quantify any material consideration given to GTII. Northeastern University, 121,000 shares. No reason to have done that. Panlunas Holdings Trust, 270,000 shares. Some kind of dubious gold transaction, not materially benefiting GTII. This one's interesting. Paul Pelosi Jr., 27,500 shares, issued under dubious circumstances, have been unable to substantiate that. Yes, this Paul Pelosi Jr. is the son of Nancy Pelosi and Paul Pelosi, of the California former Speaker of the House. I know that Pelosi is deemed to be one of the most successful traders in the stock market. Be interesting to find out why that was done, if they've returned the shares, etc. It was interesting name. Paula Hill, 121,000 shares, involved in that EMC fraud, issued under dubious circumstances. Pace College, 11,000 shares, just again, perhaps issued for the benefit of Justine Reichman's children. That's what it asserts. Line 10, page 23. Paul Brownstein Trust, 524,000 shares. Reichman is a trustee of that trust. Stock issued under dubious circumstances. Peter Dichiara, Dichiara, the holder of 68,000 shares approximately, issued under dubious circumstances. Phil Fair, 643,000 shares. He apparently was also involved in that this is what the receiver says, that EMC scheme, and the stock was issued under dubious circumstances, and the receiver hasn't been able to substantiate any consideration provided. That was 643,000 shares. Randy Clark, 275,000 disputed shares, issued per apparently a failed transaction, no consideration issued to GTII. Richardson and Associates, 458,000 disputed shares, issued at the direction of David Reichman, issued under dubious circumstances. Richardson and Patel LLP, 110,000 shares, issued under dubious circumstances. Raphael Costa, 11,000 shares. Apparently, she was a former roommate of Justine Reichman. Robert O'Connor, 660,000 shares. He was a friend of David Reichman. Again, issued under dubious circumstances, nothing to substantiate any consideration paid to GTI. Rudy Durand, 137,500 disputed shares, a failed transaction. Rachel Walidi, 110,000 shares, involved in the dubious MAC thing, and a friend of GTII. Robert Hantman, holder of 365 dubious shares. I spoke to Hantman with this regard to this matter. And again, issued under dubious circumstances. The SF Irrevocable Trust, 3 million shares, issued to Susan Fabrizio, who was the former wife of Reichman and the mother of Justine Reichman. Scott Oliphant, 137,000 shares, issued under dubious circumstances. Shay Jacobson, 200,000 shares. She was the personal tax accountant for David Reichman and his daughter. Must have done a fine job. Stock issued under dubious circumstances. Spencer J. Richardson, little over 1 million shares. Apparently the son of Mark Richardson, who I mentioned before, and I can't tell if it's Mark Richardson or the son, referring to page 25 of 35, lines 17 through 22. Can't tell which the Richardsons are referring to, but the person David Reichman used to launder stock sale proceeds, dubious stock issuance. That's lines 17 through 22. Stephen Krieg, 100,000 shares. He was David Reichman's nephew. Susan DeLuca, 374,000 shares, issued at the direction of David Reichman. She was the wife of Mike Valle, a former director of GTII. Thomas O'Reilly, 22,000 shares. She is the deceased mother of Kathy Griffin. We have T. Wang, 417,000 shares. She was the Utah accountant that filed false tax returns for GTII. And then another T. Wang, a different person, but related to the other one, 90,000 shares, the sister of the Utah accountant that filed the false tax returns for GTII. The Anne Francis Trust, 2.2 million shares. David Reichman serves as the trustee of that trust. WIMAS, WIMASC Limited, 163,000 shares, issued at the direction of David Reichman, page 27 of 35, by the way. The receiver, through his investigation, has determined this was an incomplete, failed transaction with no material consideration to GTII. And last but not least, Warren Markowitz, the holder of just over 1 million disputed shares, issued at the direction of David Reichman. The receiver, through his investigation, has determined that Markowitz worked with GTII to set up fraudulent schemes and write dubious legal opinions. The receiver has determined that the stock was issued under dubious circumstances for which the receiver is unable to substantiate or quantify any material consideration having been provided to GTII. So I think I went through about 85 of the 87. If I didn't go through any of the other ones because they were super, super small, but that is the complete and entire list of the 87 who the receiver has filed an objection to all of their shares. And that is a great step forward. If those shares can be returned, canceled, etc., then a lot of things are possible. Not just the moving forward, but to the extent there, and again, this is no recommendation or discussion about short squeezes or anything like that. But if in fact all these shares are returned, I think it increases the chances of any type of squeeze that would arise. And it would just be a necessary element to any transaction going forward. So I think this is a great step forward. I think the people who are named there are in a pickle now, and they have to decide what they want to do and how much they want to expose themselves to, what risk they really want to take the risk with all the evidence, with all the receivers reports. It seems odd to me. And again, a lot of people apparently have already approached the receiver, and we'll see a bunch of these 87 will have settled their position. So even though there's 178 million shares that are outstanding, it's probably less. And what it comes down to, it's going to be coming down to, in my opinion, what Reichman decides, because he has that 40 some million block of shares, and there's a 20 million block of shares. I think ultimately it's what Reichman wants to do and who he wants to expose and what risks he wants to expose people to. But ultimately, I don't see how he doesn't. Ultimately, I don't see how he doesn't have an obligation to return the shares based upon what we've seen. And whether he does it now or later, it's going to happen. And I think the longer he waits, the more risk he takes and the more people around him take. And to the extent anyone in the group that I named or any officers and directors have information and I can't represent what the receiver will do, but I'm speculating here. But since the receiver has a release attached to this motion and apparently would be inclined to give somebody a release if they came forward with information, if you're in a position where perhaps you were engaged in wrongdoing in this matter, I think now would be the perfect time and opportunity to approach the receiver, the Receivers Council, to spill your beans and to get some kind of release or protection, indemnity, not legal advice. But if you were my client and you came to me, that's what I would tell you to do. At least reach out and see what's available. If you're happen to be dirty, this is not like a case where something's not going to be discovered. You have a receiver who generated a bunch of reports, his counsel, plaintiff's counsel. You have a CPA firm that was re-auditing a firm that got kicked out, so it was super careful. You have a forensic accountant involved on top of that. So my guess is if you were engaged in shenanigans here, it's not going to get unnoticed. And the longer you wait, the bigger the ramifications. That's life, right? We all know that. If we have done something that's not correct, the longer we wait, usually the worse it gets, the more costly it gets, and the more future ramifications are. So anyway, if you're an officer and director in a pickle, reach out to the Receivers Council. Reach out to me. I'm happy to speak to you. Contact me. I'm happy to talk to you, and you could tell me what you want. But I really think so. Have a different view of the matter after seeing this document today. Again, it's not final. There's a bunch of legal stuff that will still go on, but in my eyes, this is the light at the end of the tunnel, and I was really excited about it. And there'll be hearing on Tuesday of next week, which I will attend, and I'll obviously comment and let you guys know what went on. Then there'll be a hearing on the 4th. And then we may have some disputes about those shares. I obviously will keep you apprised, but I think it puts everybody on that list in the non-NOBO list. I'll call them that. It puts everybody on that list at risk, and I think they really should consider their next step before they take the next step. Because I'm not just saying this, but I'm sure There is somebody beyond my eyes watching this. And if you step into it, somebody's going to be there to act upon it, is my guess. And I don't know anybody, but that's my guess. I just can't believe that that this is not a watched particular item. It's a public item in a public court, whatever. Anyway, so that's the newly filed document. I'll keep you apprised of the results on Tuesday and then the results about this hearing on the 4th and about what I hear about parties that are settling, about the end of the audit. If you recall, the audit, and I think it's referenced some in here, where I had a conversation or discussion that just waiting for the certification of that in effect, the information's all done. The audit is done, but they're just waiting for the certification from a few people that have to certify it. They were being slow and deliberate. I don't know if any of them are referenced in this. That could be a reason, by the way. And they're thinking of a way of how to get it. If somebody doesn't certify it, they're thinking about a way of working around it through the court. I don't know specifically about how it will be done, but I'll let you know. And I expect that to be done in short term also. So once all those things are done, once the claims procedure is done, if the audit's done, and then we get the shares in, then I think at that point in time, I would not be surprised if we're trading, and that might be, and not long term. I think somebody asked me last week, and they asked me they gave me two choices, 1 month or 3 to 6 months. Maybe they said 1 to 3 months, but anyway, 1 month or 3 to 6 months. And in my mind, I think I answered 3 to 6 months. And now with this going on, I think it's very possible if the audit's completed and this motion is decided favorably, I think it's going to be granted, the initial part, and then what will happen with the claim dispute, we'll see that. But I could see that period as being a period in which that might be a fair period. Now, it's still speculation, but that doesn't sound far off to me. 6 months down the road, I could see things being quite different. Could it be sooner? I guess it could be sooner. It could be longer. But this is the first time where I thought really, again, that I had, not that I hadn't felt confidence in the process, but I'm skeptical by nature. And I've been involved in enough transactions to see them go south at the last minute. So you're hesitant. So even though I could see, we've made a lot of progress. We being everybody, have made a lot of progress. The receiver has made a lot of progress. The bad guys, as I call them, are, I think, in deep doo-doo. They've been exposed. So we are really moving forward. So I had that feeling, but this first one that's going to basically, I think, attack and claw back the shares, that I saw as like the final nail that we needed to close this out. And again, as long as these things go forward in our favor, I think it's very likely that we're going to get a positive outcome. That's not legal or financial advice. That's just the direction it's going in. And again, that could change. But again, first time where I really saw light at the end of the tunnel. And I thank all of you out there for being here today. We have a nice crowd out there. But I'm very optimistic. So, and I'm not always super optimistic here, but I'm super optimistic today. And I'll stay on top of these guys. We'll not let these guys out of here, right? We keep them. We'll just keep exposing the misconduct until it's over, as reflected in the pleadings that are filed by the receiver, who has done a thorough investigation and used experts to generate those documents. And based on that, and based upon what the receiver's opinion is, we'll just continue to present the information. When they say uncle, then we'll stop. Happy to stop. Happy when everybody returns all their shares. Happy when that case is over. Happy when this thing is trading again. Happy when there's an acquisition. Happy when we can get back to having big smiles on our face because we finally have won one. And we're headed in the right direction. So let's all have a great weekend. Hopefully next week we'll have positive things to report. And that's it. Thanks for everybody for being here. If you have any questions, comments, I will check them out over the weekend. Enjoy your long weekend. And hopefully next week will bring us some really good outcomes on this. Everybody be well, take care,